You are listening to a Garris Horn Insight podcast. The opinions here are not legal advice, but listen anyway. In this episode of Garris Horn Insights, we discuss Chevron deference. Chevron deference is a legal doctrine established in the U.S. Supreme Court case Chevron USA Inc. versus National Resources Defense Council Inc. in 1984, whereby the courts deferred to the judgment of the regulatory agencies in determining whether the terms of the rules and regulations they promulgate are within statutory authority giving rise to those rules and regulations. In this episode, Garris Horn partners Rich Horn and Troy Garris, along with me, partner Ray Steichel, discuss whether the Supreme Court will overrule or adjust Chevron deference in the recent cases under review, share what Kaisering Chevron means, and the possible outlook in rules and regulation making in the future if Chevron is overturned. What we're doing today is a Garris Horn Insight podcast without video, so we get to hear us talk, which is great. Today we got Rich Horn and Troy Garris on our podcast, and one of the things I think I want to touch on first, if we can, and I think it's timely. We're waiting for the Supreme Court to rule on something that affects it, and that's Chevron deference. Right? Let me preface it real quick on. I think depending who listens to that, I mean, attorneys might know it, and if non-attorneys, maybe not as much because we learned this stuff in law school. But when we talk about Chevron deference, we're talking about regulations, right? Would you agree?
Yeah, well, let me back up and describe what Chevron deference actually is and why it's important. Yeah. Basically, a judicial doctrine from the 80s where the Supreme Court said that if the statute's ambiguous, then the courts will defer to the agency's interpretation of that part of the statute as long as it's reasonable. So Chevron deference is typically described as having two steps. Step one is the court using all of the tools of statutory construction, interpretation, has to decide whether the statute's actually ambiguous or not. If the statute is not ambiguous, then the courts will not defer to the agency. It'll just read the statute interpret the statute based on what it says. But if the court decides that there is an ambiguity, it'll kick it over to the agency, and the step two is deciding whether that agency's interpretation is reasonable or not. And so that's why you'll hear a lot Chevron step one, Chevron step two. And the reason that's important is because a lot of federal statutes can have ambiguities, especially in the mortgage industry. There's a lot of statutory requirements on agencies to do X, Y, or Z, to say what's reasonable or not, for example. But there's not a lot of very specific, very precise federal statutes. I mean, even the definition of what's a finance charge, there's a lot of ambiguity there, right? So this could have, if Chevron deference goes away and the courts are the ones who decide what ambiguous terms in a statute means, and that would have a big impact on our industry as well as the administrative state as a whole. The reason why it might go away is because two cases in this term, the Supreme Court, Loper, Bright, and Relentless, that have to deal with fisheries. And the facts in that case is that, or those two cases, is that fisheries are subject to a statute called the Magnuson-Stevens Act, and that says that the government can require fishing vessels to carry an observer to make sure that they're following the fishing laws. And fishing, I guess, is divided into a number of different areas. I'm dealing with like what kinds of fish are available in those regions, I guess. And for some of those regions, I think two or three, the statute goes a little further and says government can require observers, and then also it says government can require the fishing vessels to pay for those observers. But the other regions, it's silent on who pays. Lo and behold, Congress at a certain point didn't appropriate funds to pay for those observers for those other regions where the statute's silent. And so, the agency decided to because it didn't have funds for it, decided to make the vessels pay for the observers and interpreted that statutory silence as authority to require them to pay for it. And so that's the basic facts of the case. So in the lower courts, the court said, hey, the government can do this because the statute is ambiguous. It basically interpreted that silence to be ambiguity and said that the government reasonably interpreted the statute, that ambiguous part of the statute, to require the vessels to pay for the observers. The Supreme Court decided to take the appeal, which many scholars, legal scholars, and just people who follow the court think means that the court's going to overturn Chevron deference, which came out of, as I mentioned, a case in the 80s. And if you listen to the oral arguments in these two cases, Loper and Relentless, it does seem like that's the trajectory of the court, and also based on their other writings and statements in other cases. So a lot of people think that Chevron deference is going to go away. What that means is that the CFPB will, in cases where it's interpreting a statute that is ambiguous, won't get the benefit of the doubt from the court, right? The court's not going to say, well, this is ambiguous, so we're going to kick it over to the CFPB. Some people say this is not going to have a huge impact because in reality, the courts haven't been relying on Chevron deference, and the agencies, kind of seeing the writing on the wall with respect to Chevron, haven't been relying on Chevron as much over the past decade or so, definitely over the past few years. In fact, Chevron's not been cited in the Supreme Court in quite a while, but the lower courts, the reason why it's important, the lower courts still rely on it, and in part it's kind of a way for them to reduce their caseload, right? Reduce their workload, basically.
Right.
They don't have to do the hard work of statutory construction, and they can just say, well, this is ambiguous, so I'm going to wash my hands of it and say that the agency's interpretation is reasonable. So it still does get a lot of play in the lower courts. If it goes away, then there's two effects. One is agencies are going to get less, obviously, kind of fewer aggressive interpretations of statutes, probably, to be past the courts. But also, I think Congress is going to have to realize that they need to do their homework and actually write clearer statutes. Now, whether they do that or not, that's a question. Overarching that. Go ahead.
Yeah, and that's hard, right? I mean, that's all three of us I know have some fashion done statutory analysis. We do for a living, and clarity is not easy to write. I'll be curious to see how they come, and maybe, yes, there'll be more discipline on certain key things. But I think it's interesting because with Chevron deference, it's a double-edged sword, right? I mean, one side, it's a little more fluid, right? So in other words, we can get things done, we get regulations in place, and we now understand what we need to do. For example, in financial services, we can see at the CFPB, that's what they meant by this part of Dodd-Frank. Kind of helps out. But at the same time, it empowers regulators a little bit too much and maybe goes outside the scope, and it can be frustrating when we don't agree with it or have, we can't do much about it on our end if the courts are going to literally going to defer to the regulator. So double-edged sword. I like the fluidity of it, but I think but it also means that they can color outside the lines, as I mentioned, and I think that's problematic. So, I'm curious to see what the results will be and going forward.
Yeah, it's interesting because there's a possibility that the court will not completely overturn Chevron. They might do what a lot of people call Kaiserizing Chevron, which sounds like a horrible cleaning product, but it's actually just the name of a case where the court kind of cabined off another kind of deference called our deference, where that's the kind of deference that courts give to agencies when they're interpreting their own rules. And it's kind of similar to Chevron. If the regulation's ambiguous, that the court will essentially defer to the agency's reasonable interpretation of their rule. But the court in Kaiser really restricted this form of deference, our deference, to say, well, we're only going to give deference if we think it's a long-standing interpretation that is based on considered, fair judgment and based on their expertise, et cetera, et cetera. There's a lot of different ways they cabined it off. And so some folks say, well, Chevron deference serves a purpose, kind of takes the court out of policymaking. The court doesn't want to get into policymaking, so they might leave Chevron in place, but just Kaiserize it, put more limits. Like, for example, one of the limits could be, hey, courts, you can't just say that the statute's ambiguous in all cases. It has to really be ambiguous. You really have to work harder at statutory interpretation to say whether the statute is ambiguous or not. You can't just kind of punt to the agency. And it's, and the facts in Loper and Relentless kind of lend themselves to that, right? Because there we're dealing with a case of statutory silence, right? How is that ambiguity? The statute just doesn't say that the government can make the vessels pay for the observers. So isn't that really kind of shouldn't that just be a Chevron step one decision? It depends how the court kind of deals with that, whether they say, well, Chevron, if they say Chevron doesn't apply anymore, or we're overturning it, or if they say we're going to Kaiserize it, they still could just base their opinion, on statutory interpretation of that. That silence, to me, the government doesn't get the authority to do what they're doing. That still could be helpful, even if they just Kaiserize Chevron, because I think there's a lot of places where, like you were saying, Ray, the kind of CFPB tries to create new law. They're not just interpreting something that's ambiguous, but they're creating new requirements whole cloth without the statute telling them to do it. And they're just relying on some kind of general rulemaking authority. And does that general rulemaking authority get them there when really the statute's silent on what they're trying to do? So, that could be an interesting thing that comes out of this case. So it's definitely one to watch. There's all sorts of jurisprudence before Chevron also that could come into play. There's another kind of deference called Skidmore deference that courts give to agencies' informal interpretations, so like bulletins and things like that the courts say, well, we're only going to give it deference if we think it deserves it. Basically, if they're persuaded by the agency's interpretation, then they'll use it, which is really not deference. One of the Supreme Court justices at the oral argument said, well, what's Skidmore deference? It's really nothing. And it is kind of nothing. If the court agrees with you, they'll use your opinion. That's just basically, what everyone tries to do when they're in a case. They try and persuade the court. So it's really not deference. And that could be what takes the place of Chevron if Chevron goes away.
Right. Well, and that begs the question, right? I mean, so if Chevron deference goes away, and in our space, we're talking about other regulatory agencies, but let's just say a CFPB. And so let's say it goes away. The CFPB is going to draft the regulation, and we can look at it now and say, you know what, this is really outside the scope of the legislation, or it's not really ambiguous, so therefore you really shouldn't be drafting this. At the end of the day, the regulation will still be out there. We just have maybe a better chance to challenge it. But operationally, when I say operationally, for a lot of our clients who are banks or mortgage lenders, they don't have, it would take courage to completely disregard the regulation because of the assumption that, well, they don't have Chevron deference, they just got it wrong. Eventually they're going to get beat up on it. I think at the end of the day, you're just going to have to follow the regulation until someone comes back and challenges it back and it goes away. So in other words, I think operationally we have to be thoughtful about that. Just because Chevron deference might be either gone or has been adjusted doesn't mean that we ignore the regulations out there if we don't like them or certainly think that they're outside the scope of the legislation. We still have to deal with the realities, but at least it sounds like we have more of a vehicle to call them on it and get a double check is what I would expect, right?
Yeah, if you're trying to reduce the risk to your institution, you don't want to say, well, Chevron went away, we can do whatever we want. Hooray.
Exactly.
This is about challenges. And challenges.
We don't have lender deference. So we don't get the deference. It's not 50-50, not one or the other. It doesn't mean we gain it, right? It's just they lose it somewhat.
Yeah, no, in our firm, we've used Chevron in defending clients, like in the Townstone financial litigation, where we represent Townstone. Our main defense in that case was based on Chevron Step 1. Basically, CFPB was going after Townstone Financial for their modern-day redlining theory under ECOA, alleging that Townstone's marketing would discourage prospective applicants based on race in Chicago. But the case didn't deal with any actual applicants, anybody who actually applied to Townstone or even talked to anybody at Townstone. It was all just based on marketing to the general public. But ECOA doesn't reach prospective applicants or the general public. ECOA's general prohibition the statute, it only talks about applicants, people who've actually applied to the creditor. And so our argument in that case was based on Chevron step one. Now, Chevron, if Chevron goes away, it's still helpful, even if you're making a Chevron step one, because the agency is going to try and come back with a Chevron step two argument in its defense typically, and say, well, the statute's ambiguous, and so we interpret it this way, and so you should defer to us under Chevron step two, like they did in another case where we're defending a client against the CFPB and DOJ in Colony Ridge. We represent one of the defendants in the CFPB and DOJ's lawsuit against Colony Ridge property developers. We represent loan originator services, and our defense in that case was based on Chevron step one, and the CFPB and DOJ came back and said, well, we're interpreting this term, it's ambiguous, and so we're interpreting it to mean this. And so Chevron step two comes up in challenges, and so I think it's going to be helpful in terms of challenging rules, enforcement actions, etc. If Chevron does go away.
Yeah, well, let's see what happens. And thanks, Rich, for kind of covering that. And I think it has very real effect from a legal and technical perspective, certainly going forward. I think from an operational perspective, we got to do what we have to do, follow the regs. But
I think one other aspect of that too, just to put a little color on what the counter argument is, and I'm not advocating for keeping Chevron, but just to put it in context for our clients. So part of the argument for deferring to the agency is because it's the expert agency, right? It's the agency that actually knows something about the particular business, the particular industry, the particular regulated entities. And so as between a CFPB type that is every day involved in financial services and between a court that may hear a criminal case one day, a CFPB case the next day, an SEC case the following day, it could be that the courts will have a more erratic kind of interpretation, and you could have a lot more whipsawing and differences between the different jurisdictions, the First Circuit, Second Circuit, et cetera. And so there's, that's the rationale underlying, I think, the general notion under Chevron, and whether it's good or bad, people could probably differ and make lots of arguments.
Yeah, that's an argument that you hear often in favor of Chevron, is that the agency is the expert and they should be the ones to decide policy decisions. But often Chevron is used by courts to kind of punt the interpretations of the law, and the courts should be the ones to decide what the law says. The potential for different courts across the country coming up with different opinions on what statutes might mean is there. And one of the arguments in favor of Chevron is you have more certainty in what the law means, because courts will defer to the agency, and that will apply across the country. Often that whipsaw effect that Troy was mentioning was a good point. When you're deferring to an agency, a lot of decisions are made by a political appointee at the agency. So you could have kind of this temporal whipsaw effect. Every 4 years, you could have a change in regulations or policy. So
I was just going to say, it also gets caught up currently, in particular, in the political discussion that's going on about the overgrowth of the administrative state versus the checks and balances originally intended by the framers. So it certainly plays right into that whole conversation on every side about whether that's good, whether that's bad, the benefits of it, the checks that need to be put in place. All that comes into play.
Well, I think, and maybe it's the times that we're in, and from our perspective, our experiences, certainly in the last, say, I don't know, decade plus or minus, go figure out why. But, we've had a sense of regulation was more of a we've seen opportunity where they, again, using my phrase, they color outside the lines, right? So they've taken more advantage of the agency has taken more advantage of the regulations than we tend to think they should have. We've seen that in a few cases. You mentioned even the cases we're dealing with, Rich, and even some outside of that. So we've witnessed that, and so now we're asking for this kind of control. But I suppose in the past, and I have a, you can check me if I'm right on this, but in the past when we dealt with regulations, and all of us have done this for decades, back in the past when we're looking for regulations, we were looking truly for guidance and almost like partnership with the agency to find out how do we do this right. That's what we're looking for. We're looking to partner and give us guidance of expectations. We seem to be seeing, though, an attitude with the agencies that they are actually doing this, and I respect consumer protection, but they're doing it with a sense of force, and not so much vengeance, but much more force at the expense of those who are being regulated. And that's almost like their intention. They seem to have a different attitude. So this is coming out more now, I think, than it's more problematic now, and we see maybe a need for it more now than we did maybe 15, 20 years ago, where agencies were more about providing just guidance and co-working with us, I suppose, as an industry. And so I think we need to have this conversation. I think this has to happen, but it is situational. And so, again, things might switch later. Who knows? That we suddenly get bogged down. We don't know what to do. They don't have the authority to do it. And who knows what's going to happen in the future. But does that make sense?
One thing that might happen after Chevron goes away is the agency says, why put in multiple years into a rulemaking when we're just going to get challenged, and we don't have deference, especially rulemakings like we've seen from the CFPB where they're using very general authority to do something new. That's a risky proposition. So I think we could see fewer rulemakings, more regulation by enforcement, and more informal interpretations, because if informal interpretations are going to get the same weight as formal rules, then why go through all the headache of a formal rule? So we could end up with what some people in the industry don't want, which is just less of that black letter law that you get the benefit from following of a compliant safe harbor, right?
Well, very good. We close this one out. Rich, Troy, any last words on Chevron deference here that you add?
I think it'll depend on a read of the opinion on what we think the real effects will be going forward, and so look out from us for a blog post once the opinions come out in Loper and Relentless, and we'll describe the opinions and give our thoughts on what's going to happen going forward. And this could have effects on, like I said, challenging rules, enforcement, but don't take your foot off the gas if you start reading in the paper, Chevron's overturned. It doesn't mean that you don't have to comply with anything anymore.
Right. Yes, Troy, any last thoughts?
No, I think it's a fascinating time, especially as a lawyer, but it's a time to remain cautious. Currently, in particular, we have some fairly aggressive regulatory initiatives, and people need to keep their eyes on the road and make sure they're going the speed limit.
I agree. Thanks for your time, gentlemen, on this issue, and we'll see if we can put that up. And if any questions, people can always reach out to us. But yeah, I think it's a key issue, and we'll see when the opinion comes out in due time, see what happens and see how close we got to it, and more importantly, how we go forward. So thanks for that.